Well, most ag law is considered law by exemption, which includes paying overtime wages to agricultural workers. Well, a court recently issued a decision on whether transporting field workers for non-work related activities was within that exemption. Well, Roger McEowen with Washburn School of Law joins us now for an update. And Roger, as always, we appreciate your time here this morning. If you would, bring us up to speed on this issue.
Well, it's good to be with you, Janet. The Fair Labor Standards Act requires that ag employers who use approximately 7 workers working 5.5 days per week for 13 weeks have to pay the ag minimum wage to ag employees. Now, that's an exemption from the general rule to pay overtime wages.
So what is a farmer and agricultural employment for this purpose?
Well, they're both really defined in terms of what agriculture is, and there's a broad definition that it's used. So cultivation and tillage of the soil, production and cultivation, growing, harvesting, any ag or horticultural commodities, or raising livestock and bees and fur-bearing animals and poultry. And basically any practice on a timber farm would count as agriculture.
And what about some of the recent cases regarding this very situation?
Yeah, there was a recent case decided by the U.S. Circuit Court of Appeals for the 11th Circuit, that's down in the southeastern part of the United States, and you had a fruit harvesting company that employed primarily temporary foreign guest workers as H-2A harvest workers, and they had to provide housing and so forth as required by the law. But what happened was you had a crew leader that transported the harvest workers to town once a week to grocery stores and laundromats and banks on a weekly basis, and each trip took 4 hours, and the crew leaders weren't paid overtime when they worked over 40 hours in a week. And the court said, you're going to have to, because the activity of taking these workers to town wholly off the farm, that's not exempt as ag employment. And so they had to pay the overtime wage rate of time and a half for the hours worked exceeding 40 hours per week. And the trial court said that, and the appellate court affirmed that's not farming.
And Roger, what would you say is the big takeaway that farmers need to keep in mind here?
Well, I think the big point on this is that, yes, at most ag work, if you're within that time frame and you employ just a few employees and you're not meeting this hour requirement in the aggregate, you're going to be exempt from having to pay overtime wages. But you have to make sure that they're employed in agriculture for purposes of the exemption, and that's the key.
Okay, you can go online to washburnlaw.edu/WALTR. Roger, as always, thanks for your time here this morning. That's Roger McEowen. He's with Washburn School of Law, connecting with us today out of Topeka, Kansas.